Right, so we're actually going to get started. Hi, everybody. My name is Michael Hertz. I am on the faculty here, and it's my pleasure and privilege to co-direct the Israeli Supreme Court project with Suzanne Stone and with Ari Mermelstein, who, of course, is actually doing real work out there, manning the fort, holding down the fort. And I am not just delighted, but really impressed that you are here. It's actually a beautiful evening now. Okay. Yeah, right. It was sunny, you know, but 5 hours ago it didn't look that way. We had a lot of RSVPs for this event. You know, if all activities had the sort of success ratio of attendance to RSVP as this one did, we would all just have to go home and give up. But it's great that you're here, and as the justice was saying to me earlier, what we lacked in quantity, we more than make up for in quality. And so thank you very much for coming. I'm not going to introduce the panelists because it's Stein, my colleague, will do that. I'll just say that Ed, the moderator, who can't introduce himself, is a longtime Cardozo professor, former vice dean, and runs the family law program here at Cardozo, leading family law professor. And I will just turn it over to him. So thank you again for coming.
So our plan for tonight, first of all, is to keep it relatively informal given the small group. So if people want to come closer to make it more conversational, please do, or not. We also lost one of our panelists because of the weather, but we have two very distinguished panelists who are here, and they're going to each speak, but then we're going to very quickly after they speak open it up to an informal conversation. And given that we have just two panelists, and I'm going to just very, very briefly introduce them. First, immediately next to me is Justice Daphne Barak-Erez from the Supreme Court of Israel. She was previously, before she became, before she joined the Supreme Court, a professor at Tel Aviv University, whose work was in administrative law, comparative law, constitutional law, and feminist jurisprudence. And then next to her is Shahar Lifshitz, who was a former visitor here at Cardozo. Twice. He is a scholar of family law who's written several books, numerous articles, and now is the Dean of the Faculty of Law at Bar-Ilan University. So we'll speak in the order that I introduced our panelists, and then we'll open it up for conversation.
So I'm delighted to be here, and I'm also delighted to see the growth of the Israeli Supreme Court translation project, and I think this is a very important endeavor that Cardozo Law School took upon itself. And in some ways, or in many ways, our evening today is celebrating this project, and also maybe gives it, I would say, meaning in the sense that it's not only about translation, but it's also about knowing the cases, discussing them, and understanding their potential to become part of the legal discourse. And in fact, this is what I'm going to do in my short presentation this evening. I'll try to describe some of the landmark cases of the Israeli Supreme Court on issues of fertilization and controversies about parenthood. And I'll try also to put them in a cultural context of the importance of maybe fertilization issues in Israeli society, Jewish tradition, because in some ways, and maybe this is going to be my introduction, it's impossible, I think, to understand Israeli case law on these issues without understanding the degree to which they are rooted in our culture and in our social context. Indeed, parenthood is considered one of the inherited traits of humankind. But at the same time, there are also aspects of this aspiration that are culture dependent. And if we're talking about cultural dependency, so of course the issue of fertility, of having children, is something very meaningful, very central to Jewish tradition in general, and also very relevant maybe to social realities and more recent traumas of Jewish modern history. Of course, the first thing that comes into mind is the Holocaust. So in order to understand the centrality of these issues in Israeli law, we should really have this broad perspective about the issue. On the top of that, we should also mention that Israel is a leader in the area of medical interventions in the area of fertilization. So in addition to the layer of culture, there is also the layer of medical research, and also the fact that the state in Israel supports fertility in a very benevolent manner. Fertility treatments are part of Israel's national health insurance law, so every woman in Israel is entitled to get fertility treatments if she so wishes. So in Israel, having children is not considered a privilege, but rather a right, and some would even say a social duty. So in this context, we can understand how important and how central are controversies about fertility. Now, proceeding from this very brief background to the legal landscape, I will start by saying that the overarching question in this area is whether what is feasible from a scientific and technological perspective should also be possible and feasible from a legal perspective, because these two issues are not identical. Of course, most of us would agree that these two areas would not always coincide. Of course, not everything that is possible from a technological perspective should be legal. But at the same time, I think it will be naive to think that the new scientific and technological possibilities will not influence and reshape the scope of legality. So we have here a very, very complex connection. Of course, I will not be able to address all, the questions that emerge from this very general introduction. So more specifically, I will start by distinguishing between what I call two types of litigation and controversy in this area in general, but of course I focus on the Israeli context. And I term these two types of litigation horizontal and vertical, and I will explain. The horizontal controversies are controversies between at least two private parties, usually partners, who have different aspirations regarding a parenthood project to which two of them became involved in. For example, think of two partners who started an IVF procedure and only one of them would like to finalize it. This is the model of the Nachmani case that I will touch on later, and of course you have many similar controversies in the US, of course starting from the quite very well-known case of Davis v. Davis and others, but I will address the Israeli main landmark case in this context. And there are the vertical controversies. These are controversies between an individual or individuals and the state, when the state or one of its authorities does not let that individual to move forward with technological possibilities that may lead to aspired parenthood. For example, whether surrogacy is legal or illegal, or whether it's legal for some and illegal for others. This is a different kind of controversy because it's the individual vis-a-vis the state. It's not a controversy between two individuals. So these are two spheres of controversies or legal conflicts. Of course, in some cases, the two types become interrelated. For example, when the state does not allow surrogacy for example, same-sex partners, and one of the partners would like to promote it abroad. So sometimes there may be an inner clash, but also an external clash with the state. So we should distinguish between the two types of controversies and at the same time understand that in real life they sometimes may emerge together and make life for us more complicated. For the reason I stated in my introduction, the Israeli Supreme Court has been an arena for many interesting new case studies exemplifying these two types of litigation. And in my presentation, I will just bring to you very briefly some of these Nenbar cases. I already used 5 minutes or so, okay.
We're going informal here, so you can
Okay,
take the time
there
you
are
need.
privileges in snowy days,
Yes.
okay? So I'll start with the case studies over horizontal litigation, not necessarily because they are more important, but also in terms of history, these were the kind of controversies that emerged first, at least in the Israeli context. So the first and most famous case in this context is the so-called Nachmani affair. It is called after, the case involved the story of a married couple whose family name was Nachmani, and hence the Nachmani case. They also had names. This is the case of Ruti and Dani Nachmani, who started to go through IVF procedures that were planned to be completed in surrogacy, since Ruti could not carry a pregnancy after she lost her womb. So this was the basic the basic facts of the case. In the midst of this procedure, when the already started the procedure but never completed it by with the surrogacy stage, the couple separated. Ruti wanted to move forward with the procedure, which carried for her the only possibility for biological parenthood for several health reasons. She couldn't have more procedures of the same kind. She didn't have the biological capability for that anymore. So for her, it was the only the possibility for biological parenthood. Whereas Dani, who already had a new partner and children with the new partner, did not want to go with the IVF procedure. And the matter was brought eventually to the Supreme Court. It started at the district court level, but I'll have to really summarize the main stages. And what was particularly interesting about the proceedings in this case is that the matter was decided twice by the Supreme Court. In the first round, it was decided by a 5 justices panel, and in Israel there is a special procedure of rehearing of a case by an enlarged panel if the case involves a new presidential question, and this was indeed the case. And the president of the court has this special power to decide about rehearing in an enlarged panel, something that you would not know in the American context, because in the U.S. the federal Supreme Court always resides with all its justices, but we have a different structure. I'll not get into all these details because this may be the subject of a separate presentation. Anyway, so in the first round, the court decided it by a large panel of 11 justices. And the decision changed. By the way, for me, it's a very interesting case to report, because as a young academic, I wrote a few articles criticizing the original decision, and then the result changed, not because of my articles, but still I felt involved, not as a justice, which may be relevant to some of the cases that I will discuss later. Why did the court decide for the partner who resisted the promotion of the process? The Supreme Court in the first round stated that the right to be a parent is a more burdensome right, that it puts burdens on the other side, whereas the right not to be a parent is a less burdensome right from, I would say, a formal perspective, this may be right if we think about money, if we think about legal duties. At the same time, it may be too extreme to say that insisting on the right not to be a parent did not put any kind of emotional burden on the other side. So it really takes us to a very significant questions about what kind of burdens the law regards as relevant to decision making. Anyway, this result was changed by a enlarged panel of 11 justices. It will be too difficult to try and describe to you all the various justifications and arguments offered by the new majority in the enlarged panel, because there were various, I would say, reasonings offered, but mainly, if I want to be very general, I would say that the new majority, thought that the new decision is the just decision. Of course, under the assumption that this is a new scenario that is not really decided by any particular law, and hence the court has the role of doing justice. Of course, the question is, what kind of justice? What are the reasoning for justice? There are different ways of thinking about justice. Anyway, this was the decision. I will be able to elaborate if we have time. Now I will jump from this decision to another decision that was given years later, and a decision that has some resemblance to the Nachmani decision, but also was different from it in many ways. And I also have another kind of personal attachment to it, because here I was already part of the panel as a justice. And this case has a less memorable name. Using American legal language, I would say that it may be called the Jane Doe case, anonymous, because in some of the more sensitive family law matters, the decisions are publicized without the names of the actual parties. What was the story here? It was a story of a woman whose wish was to proceed with an IVF procedure using the sperm of the anonymous donor who was the biological father of her daughter. This may sound too difficult, so I'll try to rehearse it in a more simplistic manner. A woman applied to one of the sperm banks in Israel. She wanted to have a child and gave birth to a healthy child. She was so happy with this birth, so she decided that she wants another child by the same donor in a way that will guarantee that her two children will be full siblings from a genetic perspectives. But something happened in the middle. In the time that has passed since the first pregnancy, the donor approached the sperm bank and expressed his desire that his sperm will not be used anymore, because he had a change of heart. Of course, he takes full responsibility for any donations that were already completed, but he said, since then I married, I have a child, I see the idea of a sperm donation in a different way. Please respect my feelings, don't use my sperm. The bank sperm decided to respect his wish. Therefore, when the woman applied again and said, I want to go on with the process with the same donor, the sperm bank stood with the side of the donor. Obviously, the involved individual, the mother, was not happy with the result, and she brought the case to court. Very interestingly, although in essence this is what I would call a vertical type of litigation between the prospective mother and the prospective father, from a formal perspective, this was the opposite, horizontal. What I wanted to say, I already thought about my next sentence, but in fact, it got to the court as a matter of vertical litigation. Why? Because she brought a petition to the Supreme Court against the sperm bank. Because the sperm bank, from a purely legal perspective, was the relevant litigator, not the anonymous donor that she didn't even know. And this is another way of showing how the two types of litigation or kind of conflicts may eventually come to court intertwined with one another. In some ways, it's similar to Nachmani, but it's very different from Nachmani in many other ways. First, for the woman, it's not her only chance for parenthood. In fact, it's not about parenthood, but rather a desire to have a very specific kind of parenthood. Parenthood with the same donor. And for this reason, eventually, again, I will not get into all the details, despite, I would say, the simplistic, I would say, the simplistic comparison between the two cases, in essence, they are very different, and for this reason, the court unanimously, and I was part of this decision, decided for the donor. Because this time, it was not about materializing the right for parenthood, but rather about a very specific wish that we could understand, we could sympathize with in normal circumstances. The question was whether this sympathy is enough in order to make her victorious over a very strong felt wish of the donor not to become a father to unknown anonymous children in the world. So this is another similar but very different example for this kind of conflict. Now I will go to real case studies of vertical litigation. Here, I will address real controversies between the individuals and the state. And I will bring, in this context, three types of cases. More than that will be too much. I'll start with a major category, which I would say is very relevant to many typical cases. And this is the issue of access to surrogacy. You should know that in Israel, surrogacy has been incorporated into Israeli law by a special statute enacted in 1996. By the way, the Nachmanis and other couples had their contribution also to the enactment of this law, because I will only say in a footnote that when the Nachmani controversy started, the plan of the Nachmanis was to have an IVF procedure in Israel and then go on with surrogacy in the United States, because at the time surrogacy was not legal in Israel. In the meantime, the Knesset decided to authorize surrogacy in Israel, but subject to conditions that will be very relevant to my current presentation. So in 1996, the Knesset passed a special law on surrogacy, which was a relatively big step forward. But the Knesset at the same time decided that the gate to surrogacy will be opened only to, I'm saying it in a descriptive manner and not in any normative manner, to normative traditional families. The law is not written in these words, but this is what, in essence, the law is about, because in principle, the law opened the gate to surrogacy only to heterosexual couples. This means not to same-sex couples, and also not to individuals who don't have partners. At the time, this was considered a big step forward, and also part of the reasoning was that let's move forward with something that is relatively consensual, and then it's a matter of, I would say, social laboratory. So this may be a first step or not, but this was the law as it was enacted. Many years ago, a petition was brought to the Supreme Court about this limitation, about the fact that surrogacy is not open for everyone, and the petition was brought by a woman without a partner who claimed that the surrogacy law is discriminatory also against individuals who don't have partners. Since this was a case that was decided a relatively short time after the passage of the law, the reasoning of the court at the time was that the petition should be dismissed because this is a new law, and that there is rationality, there is reasonableness in the Knesset preferring to go on a step-by-step basis, not to open the gate to surrogacy with no restrictions. I will not comment on the present time because this may be something relevant also to petitions that are open. I will just say that the reasoning of the old case was very much connected to the fact that the petition was brought to the court relatively close to the passage of the law. Since the passage of the law, 20 years have passed. So the question is open whether the old reasoning that was given there, then is still relevant, still convincing to the same degree. I will not say more than this. I'll just say that this is an open question. So just to define one of the big questions of the vertical controversy, the scope of entitlement to surrogacy in Israel. By the way, what happens with all those who are not entitled to move forward with surrogacy in Israel? This does not mean that surrogacy does not happen also for others, but it is very much based on, I would say, globalization and the ability to move and use medical and legal resources of other countries. People just go abroad and move forward with surrogacy and then come back with their children. This, of course, raises other issues because this may mean that for those who cannot move forward with surrogacy in Israel, they need to invest more money, they need resources. They are also dependent sometimes on the medical capabilities of other systems. Not all systems that recognize surrogacy are friendly to the same degree to people who come from abroad and want to move forward with surrogacy. Some countries that were open to Israelis in the past are not as open today. It really depends on the legal approach and political approach of other systems. So the limitations of Israeli law do not completely limit those who are not covered by the law, but still moving forward with surrogacy abroad is not identical to the ability of promoting it in one's home country. Again, I'm saying all these facts in a descriptive manner, and I leave it to your judgment. There are other, I would say, arenas for the so-called vertical controversies. I'll just mention a few other stories in a very short manner. And now I'll go to a very extreme and different example, the example of a so-called creating a baby. This was a very special case that was decided less than 2 years ago. It concerned a woman with disabilities who badly wanted to become a mother. She couldn't become a biological mother, and also there was no legal way she could go ahead with any kind of fertilization project in Israel. So she managed to so-called create a baby for her outside Israel. She initiated a fertilization process based on a donated sperm and donated eggs, and also moved forward with a pregnancy by a surrogate mother. So she really planned and created a baby project for herself, and then wanted to raise him or her. Very understood on the emotional level, but also very problematic if we think about the meaning of creating a market for babies. And this is really a very extreme case where the emotional desire is, of course, understandable, but the social prices are very high. and the Supreme Court, with sorrow, had to decide against her because of all the presidential meanings of recognizing such a possibility. By the way, you could see that this is a case that was totally debated in the vertical level because there was no clash with any other specific individual. It was merely about the question of what is the scope of legality of moving forward with what is feasible from the technological and scientific perspective, the overarching question that I mentioned in my introduction. No, if she can,
Take care of the
if she can nurture the child and yes, the child already existed. She came to Israel. She said, "This is my child. I want to raise him or her." This is the idea.
He was born in Israel. She didn't came to Israel.
Yes, yes.
He was born in Israel.
Yes. The decision
The baby
Yeah.
was taken for him.
to adoption. This is why this was so hard, because on the emotional level, one can understand, this miserable woman, but from a social perspective, the question is whether the court is going to okay such creations, that people will create a market for themselves. And out there in the globalized world, everything can be done somewhere. Of course, the government, the Attorney General, the state is responsible for the benefit and the well-being of every child that exists in the country. Parents cannot decide to sell their child to another couple and just imagine that the two couples are happy with the contract. Does this mean that the legal system can get along with such an idea? So it's the same concept. It's just a more extreme expression of the same question. Yes. Of course not. The whole idea was that it was not her child. She had no biological connected to it. That was all. Of course, there is full respect to parenthood rights of people with disabilities. The whole problem that it was about the problem of creating a market for babies.
But how could this then adopting babies?
That's the whole difference in the world, because the adoption process is a public law process. The state is involved. It's not a matter that is left to the market. The question is whether there is a decision-making process. What is the justification for giving that particular child to that particular family, which is being assessed before, and it's not a matter of money. It's not a matter of the ability to pay for the baby.
What do you mean? An adoption is taking the baby.
Not at all. Not at all.
In America, you take
Well,
you adopt the baby.
in conceptually, and especially, let's start with Israeli law. In Israel, adoption, in principle, is not based on paying anything. It is indeed true that there are not enough babies for adoption in Israel. So I will not tell you that there are no Israeli couples that go abroad to adopt and sometimes pay, but this is something different. The concept in Israeli law that is adoption is not about money and it's not about market for babies. But again, we cannot open now all the boxes with new questions. What is, I think, a concept that is being shared by all civilized legal systems is that basically parents cannot sell their children to those who can pay for them. This is, I would say, some common idea. And the understanding of that particular case was that this is just a new type of market for babies, although it's not the old type of a baby being born to parents and then after the fact being given or sold to another couple who has interest in growing him or her.
So we said this would be conversational, but
Yes.
why don't we
Yes, so I'll
finish your
just
presentation,
I'll
we'll
just
get
try
the
to very
statistics on the table,
to
and then we'll have
very
even a
okay
broader conversation.
to very briefly maybe give one last example that is based on a very recent case that was decided by the court just like less than 2 months ago, so very recent, so maybe worth mentioning, maybe not all of you have heard about it. And this will bring to the room not only the right to parenthood, but maybe with a question mark, the right to grandparenthood. And the basic facts of the story are the following. The question is, or the case was about the possibility of bereaved parents to ask for the use of the sperm of their deceased son in order to fertilize a woman in a manner that will allow for materializing his unfulfilled parenthood. Could you follow? The idea is that parents lost their son. There is a technological possibility to save his sperm, and the question is whether the bereaved parents can claim and then move forward with a process of fertilizing a woman who will consent to it, of course, to give birth to their grandchild. Here, there is another possibility of bringing together horizontal clash and vertical clash, because one question is, of course, on the vertical level, whether the state will allow the bereaved parents move forward with such a process. But the horizontal clash comes when that son already had a partner. What is her standing? Should she have the priority in making the decision, or maybe the parents should have the priority? And what if they don't think in the same direction? Of course, sometimes there is no partner. Is it important? Is it relevant whether that person had or did not have a partner? In what way it weighs? This is a legal question, but it's also a moral question. It also has very particular, I would say, twists in Israel, because sometimes the question may rise in the context of a son who was lost, for example, in the context of military service, and then not necessarily this is the case, but it may be a very relevant context in Israel. Does it matter if the state maybe took in some way, of course not willingly, the life of the son? What is the role of the state in maybe safeguarding potential parenthood? Is it important what the deceased thought? Should we care whether he wanted to have children and whether he wanted to have children even when he's not alive, which is not necessarily the same, because we may imagine people who love children, who would like to have children, but will not necessarily would like to have children that are raised and brought to the world with the knowledge that they will not be able, just a minute, to be with them and raise them and nurture them. The case came to the court in a especially aching manner, because it was a case where there was also a clash between the will of the living partner of the deceased and the will of the parents. The parents wanted to move forward with the fertilization process. By the way, it was not their only son, which could be even worse if it were, but it was not the case. So they had other grandchildren, but they wanted to have grandchildren also from the deceased. And his living partner did not want to move forward with the process. She already had another partner, she had children, and not always that she didn't want to move move forward with the process. She also resisted the idea of using the sperm of her deceased partner with another woman. This was a very aching and difficult decision. I'm sure that there will be a division of opinions even in this room. There was also on the court, so I'll just report and tell you that the majority decided against the parents. With all, I would say, the understanding to their emotions, the basic reasoning of the court was that what we should care about is the will of the deceased and not the will of his parents. And that usually the best way to assess the will of the deceased is by looking for the opinion of the partner who was expected to be his or her partner for life, at least from what we know in the minute of in the time of his death. Again, with all the understanding and maybe even sympathy to the emotions of the bereaved parents. By the way, this was the majority opinion, and there was also a minority opinion. How can we imagine such a case without a majority and a minority? Because there are strong, I think, arguments or at least emotions on both directions. To conclude, because we also have to hear Shachar and we want to have more discussion, I'll just conclude by saying that Israeli law is, as you could already see, a pioneer in the area of fertilization law. Some would see this as a blessing. Some would evaluate this as expressing some kind of baby ecstasy in Israeli society. It really depends on one's perspective. Anyway, it is a very, I would say, lively area of law. And maybe I will end by saying that another very relevant angle for addressing the matter is the allocation of powers and roles between the courts and the legislator. Many of the above discussed controversies were raised before the court before they were regulated by the legislator. And it is interesting to see that this is one of the areas in which judicial activism is usually not criticized, but rather praised. At the same time, it is difficult for the court to move ahead beyond a certain point without guiding legislation. Thank you.
The law of nature is that the natural mother and father have custody of their child, raise him, love him, care for his needs until he has grown into an adult. This is the instinct of survival within us, the call of the blood, and the bond is stronger than any law and lies beyond society, religion, and state. It was not state laws that created the right of parents vis-a-vis their children and vis-a-vis their vote. These statements are taken from a very famous adoption case in Israel. However, they reflect in a lot of sense Israeli law view about who is parent, which is the topic of my talk today, and it reflects the fact that the official story of Israeli law say that basically parenthood is, or the question who is parent is a biological, there is a biological answer, with one known exception, which is the formal adoption, which adoption is the exceptional. We know that it is exist, and in adoption the parents are not the biological one, but there is a very rare circumstance which are just in a very crisis cases in which we allow adoption. But without adoption, we know that the answer who is a parent is not a legal one, it is a natural one. It is and this is the biological parents. And what I am going to do most of my lecture today to show that even in the existing law, beyond the biological, which at least in case of mother can be genetic or the birth mother, but beyond the biological and the adoption, which are the known parental definition, there is also the family status, which basically regarding father means that the father are the husband of the mother, and we have contractual intentional tests which say that parents are the people that agree that they are the parents, and we have also functional psychological parenthood, which say parent is the one that take care for the children or function as a parent. And what I will show in a variety of circumstances or a familial situation, how all of these definitions fight each other, and how definitions that we declare in one situation then doesn't work for us in another, and how the court try to handle this situation. So most of my talk will focus on existing law, and I will invite you to go with me to journey about variety of familial situations and see who is the parent in each of them. This will be my main talk. Then I will try to argue that this fight between different definitions covers the fact that parenthood is not natural, but it is social construct, it is institution, and the third aspect of my talk will connect it to Judge Barak Erez's talk, because I will try to argue that if we take seriously the fact that parenthood is a social institution, it may change our mind also about what Professor Barak Erez called the vertical dimension and the supervision of the state about artificial regulation. So these are mainly the three parts. But let's begin with our journey. So the first case, which in a way it is a seminal case about the definition of parenthood, is the case of children that born of extramarital relationship to a non-married woman. So as you know, in a lot of countries until the 19th century, these children are considered illegitimate children, and in some countries it means that they didn't consider the children of their fathers, which was a lot of legal meaning. And also in Israel, according to the Islamic law, these children are not considered to be the children of their fathers. They don't have father, because the definition of fatherhood in Islamic law is the husband of mother. So if you are a non-married woman, it means that your children doesn't have a father. And now we are coming to the civil law in Israel, and we will show that this case was the origin of civil law in Israel to insist how parenthood is about biology, because they want to oppose this familial test, and I will also show that they want also to oppose the contractual case. But unfortunately, because they were so strict in saying we adhere to the biological test, because in this case it is very justified, they find themselves in other cases in a problem situation. So let's begin. So in this, as I said, in this situation, the genetic father is the father according to the biological definition, and Israeli law rejects the familial definition of illegitimate children as it appears in traditional and religious law. In such cases, the court used the terminology of the call of the blood as an expression of the natural aspect of parenthood. There is a very excited case of Judge Cheshin, Zichrono Livracha, which about a girl that was born to Islamic family outside marriage, and despite the fact that according to strict law in Israel, Islamic law should be applied. Judge Cheshin made extremely activist move in order to say first that the case will not be subject to Islamic law but according to civil law, and then we say, and according to civil law, our definition of parenthood is biological one, the call of the blood, etc., etc. So, in this aspect, the Israeli insists that they reject the familial test. And what about the contractual? In this genre of cases, there is a genre of situation in which the woman is pregnant, and then the male say, I want you to have abortion, and she refused. But in part of these cases, she say, but you know what? You don't want to be father? Good for you. I don't need you as a father, because if you are a father, you already have authority according to the children. Let's make an agreement now in which we say that you are not the father, you don't have the duties of a father, but also you don't have also the authorities and responsibilities of father. And so in our terminology, this is the contractual intentional case. So here again, the court insists on the biological test and totally rejects the contractual test that says that someone can agree that he is not the father. In Plony versus Almoni, court made it clear that agreements that negate parenthood are in public policy and are not to be validated. And I would say that in few of these cases you can say that it is because power gap and things like this, but the court made it clear that it is not about gap of power, but it is RM public policy that someone would declare I am not the father and agree about this issue. And I would add that in this circumstance, court and then legislation make effort to catch the non-wed father. For example, if it didn't want to undergo a DNA test, so originally they say, okay, if you don't do it, it means that you are the father. And today there is even legislation that enable to force him to pass a certain kind of such a tested. So the law insists that biological father will take responsibility for his parenthood. And also the last aspect of the fight for the biological definition in this aspect is the cases of unintentional parenthood. In Israel we have some cases in which fathers claim that the female cheats them and say that, and in all of them the court saying this is no excuse for not taking responsibility about the kid. So if I summarize this first scenario, this is the scenario in which the court on one say in a clear voice we have a biological definition and we reject both familial and contractual alternatives. Now we are moving to the second scenario. The case of children born to married women in extramarital relations. Now we have to take in mind that in Israel, marriage and divorce law are according to Jewish law. And these children will consider mamzerim, bastards, which means that they will not allowed to get married according to Israeli law, and this is a big disaster. Now, in Jewish law itself, there is kind of ambivalency regarding mamzerim. On one end, when you are declared mamzer, then you are not allowed to get married. On the other end, we don't want really to declare you as mamzer. We don't want to catch you as mamzer. We want to, we can say, don't talk, don't ask. Okay, so what happened in this kind of cases? Officially, the biological father, not the husband, should be recognized as a legal parent if we take seriously the biological test. However, what Israeli law did, and again it was cases and then legislation. Case law and more recently legislation have almost completely prohibited DNA paternity testing for children born to a married woman when the husband is not assumed to be the biological father. In the absence of this option, the husband is considered to be the legal father based on evidentiary presumption according to which, in the absence of evidence to the contrary, the husband is a biological father based on the assumption that the woman is sexually active with her husband. So on one hand, they don't allow you to make the test, and then when we don't do the test, we need a default, and the default is that children belong to the husband of the mother, even if we assume that this is not the situation. So in practice, the family test is adopted in this situation. We should admit that they did it not because the familial test, but because the best interest of the children test. However, it is a very narrow way to look at the best interest of the child, because you can say that sometimes it is very important to the child to know the truth, and here the whole focus is about the question of not to treat him to be considered as a mamzer. Now we are moving to our third situation, which is connected to sperm donation. So, and let's begin with sperm donation without the husband for a single woman. So, in the absence of a direct provision regulating sperm donation, the biological genetic test ostensibly applies according to which the donor is considered to be the father for legal purpose. Again, there is no law, so if there is no law, and if in Israel, as we just say, the biological test is the only test for parenthood without the exceptional of adoption, it means that the sperm donor is the biological father and is a legal father. Since that you have someone that somehow succeed to expose the identity of the donor, it will be accused to pay child support, for example. However, nevertheless, the fact that the sperm donation in Israel are conducted anonymously produced a reality in which the biological genetic father is not recognized as such and is not obliged to meet the commitment of parents towards their children. So formally he is a father, but as a matter of practice, we make a mechanism that enable a biological father, what we call the legal father, not to take the responsibility. Now, what happens now if it is a married woman, not a single? So, so here the mother is a mother, but what about the husband or the spouses of the mother? So, if we look at it from a biological test, so the husband, in this case, is not the father. However, in this case, there is an interesting old case, Salme versus Salme, in which the court tried to apply the contractual test and say that because the husband was part of the process, then he agreed to become a father. But here is the problem, as we just say, no, we are not ready, since Ploni, we reject the contractual test. So what court will do now? So they going part of the way. They say, we are not recognize contractual parenthood, but for the specific limited target of child support, you take upon yourself the commitment to provide the children. By the way, they didn't do it regarding will. Why? Because in will there is no concept of implied will in Israel. So because it is not contractual parenthood, but just contractual duty to pay alimony, it is limited just to things that you can committed by agreement. So this case demonstrates the tension between the attempt to maintain the ethos of biological parenthood on one end and the reality in which consent is increasingly becoming the basis for imposing a parental obligation on the other. Now, I promised at the beginning that I will just describe, but I cheat because now I have one slide in which I cannot limit myself from little bit normative inquiry. And I feel that there is kind of tension between the biological approach, including the objection to agreement in which the father attempts to opt out of his biological fatherhood, and the approach increasingly followed by the court regarding artificial insemination. Because from the perspective of the best interests of the child, if we take seriously the case, the Plony case, which say it is RM public policy that parents will agree that that father is not a father. Why? Why it is so terrible? So I can look at it either from the perspective of the children or from the perspective of the behavior of the father. So if we think about it from the perspective of the children, and we really think that it is not good for children to be born without father, how it comes that the law enable sperm donor a mechanism that make it clear that there will be a child that will live without a father. Moreover, there is a Supreme Court case which rejects policy of the state that say that if a single woman want to enjoy sperm donors, then there should be specific economical inquiry enabled to show if she can make it alone, and the court say it is non-egalitarian, and it rejects it. So if the court think in this case that it's okay for single women to take care for her children, and it is not even legitimate to make any inquire about it, how it comes that she is not allowed to agree that she don't want another person to be the father if both of them agree. Now, if we are looking at it from the perspective of the father, then again, so what is a claim? Okay, she's okay, she can use to it, but it is non-moral that father will neglect his children. So again, if we define father as genetic father, so how we make a mechanism that enable father not to take responsibility for their own children. So how we can settle these two issues? So one option is say, okay, you're right, there is a real problem in the situation of sperm donor. However, we have another interest. The other interest is the right to be a parent. This single woman has a right to be a mother or a parent, and we really appreciate this legal right, and we know that the anonymous of a donor is extremely important ingredient to enable it to fulfill his right. But if this is our excuse, it means, and we should say it, that we think that we are doing terrible things either to the children or to the morality of fathers, but we are ready to do it because the right of mothers. Other ways that we can go is to make some distinction. One distinction is about the anonymous. Somehow we should explain why the fact that in the Plony case we know who is the father make it terrible that he say, I know this is my children and I neglect him, and if you are anonymous from the beginning, this is okay. So what is terrible is not the fact that you have children that you are not taking care, but that you have known children. Other option is, and I will is a state supervision. That it is not a private transaction, but there is something that establish a procedure to do it. And the third option is a timing. That somehow the fact that this is what we plan from the beginning make you a donor and not fathers that neglect your parents. And all of this explanation together will lead me eventually to the understanding that it is something about social construct and institutionals and not just about nature, and we will come further to these aspects. Now, let's continue with our journey in a variety of situations, and let's talk about egg donation. So here there is a law, not and here it is the first time that the Israeli law admits they neglect the genetic test, but look, because there is a biological parenthood, then there is a distinction between the genetic and the birth mother. So here, because there is other biological definition, maybe make it easier from Israeli law to neglect the genetic one. So here, the law say officially, in Article 42 of the egg donation law, state a child born of an egg donation is a child of the recipient for all intent and purpose. However, but there is one exception of marriage and divorce. So here, by the way, my wife has excellent lecture about the status in the Ilchatic law, but this is for next time. Okay. Now let's move to surrogacy agreement. And here it's first time, here again it is law, legislation, not Supreme Court cases. And here again, here is first time that we have something that's similar to contractual regime, but it is more quasi-contractual. Because the surrogacy agreement law allows the intended parents to enter to an agreement with a surrogate mother. However, it is not like you mentioned, there is money, but there is a committee and there are rules, so it is extremely supervised. It is not freedom of contract in a deep sense, it is more compensation than market in the deep sense. And even in the law itself, there is ability to regard. According to the law, the agreement itself, it doesn't determine parenthood, and as such, it ultimately requires a parented order from the court. So here again, the law doesn't say that the agreement itself is enough. To make it parenthood, the law should make official order, and there is partial ability of the surrogate mother to withdraw before the parenthood order is issued by the court. And as the Judge has mentioned, same-sex couples and signals are excluded from this law. So what is the solution of same-sex couples in Israel? So sex couple in Israel have some solution. One of them is go abroad, find states that will recognize your parenthood, register then there as a parent, coming back to Israel, and then there is a trick of the Supreme Court that say, look, if you are registered in other country as a parent, then we will register you in Israel as well. It doesn't mean that you are really parent, but we register you. And if we register you, as a practical matter, it means that in a lot of aspects, not in all of them, we will refer you as a parent. So this is one aspect. Second option is to adopt the other partner child. This is mostly good to lesbian females. They have, one of them has biological children, and then the other adopt it according to Yeros Haka case. theoretically, there is a possibility of obtaining a child for adoption from an agency, but it is extremely rare case that it is already done. And the most popular one is recognizing a surrogacy overseas and the development of judicial parenting order. So they make the process abroad, coming back to Israel, and then there is a practice in which the court, in an analogy to the surrogacy agreement law, make kind of invention of the court which make parenthood decree that recognize ex post what happened abroad. Now, additional explanation of the contractual approach to parenthood. So one case is what we just say, it is about the issue of surrogacy overseas, that in Israel become extremely popular from same-sex couple, for signal, and to other person, for example, adult parents that will not be allowed to make the process in Israel, and then they just came aboard, and then in a very complex procedure, lower court, this is not a process of the Supreme Court, by the way. This is a bottom-up process in which lower court developed the ability to recognize this overseas surrogacy process. The second issue is the project of biological will, which Judge Barak Erez described in the last case. This last case is, I would say, that the Supreme Court function as, I will call it normatively, as a responsible adult to stop a process which begins, by the way, not only in the lower court, but there is a famous organization in Israel called New Family, which is one lawyer which has an extremely market ability. And she used this terminology, biological will and product. It is a product. They sell a product, and the product is biological will, and they use this market terminology. And interestingly, this process also supported philosophically by Professor Asa Kasher, which he was member of one of the legislation committee, and he say that one of the main issue of parenthood is that there is something that will be your kaddish, someone that will continue your way, and the law should support it. And until this...
And he is a bereaved father as
yes,
well.
as well, which is... Oh, yes, I think
Apparently relevant.
and there was some lower court cases in which they support this phenomenon again and again until the Supreme Court case which Professor Barak Erez mentioned, and yes, and the case that Professor Judge Barak Erez mentioned, the Mor Yosef case. This is one of the rare cases in which the court allowed to make names, and their name is Mor Yosef. Is also a cases in which the Supreme Court make slow the phenomenon of making a market of babies. I will say in person that I support the Supreme Court case in this aspect, but I am the dean, and our disability clinic present this woman in the court, and people ask me how it come if you that this is academic, that they have, of course, their freedom, but I told them that I think that the Supreme Court was right, and I oppose it in advance, but they did it. And now, very quickly, I make some normative reflection. Maybe we will continue in the discussion. I think that the journey that we did prove that parenthood is neither nature, but it is not contract, but what we really need to admit that it is institutional, and if it is institutional, then we have to take seriously what are the conditions and what is the definition of parenthood as a society we want to adhere. And here my intuition is that if we take seriously parenthood as a institution, it will have influence not only on the question that I begin with parents, but also on what Judge Barak Erez say about the vertical dimension, which kind of process we should allow, which kind of ethos of parenthood we want to support, and I have some thought, but maybe we will continue with this thought in the discussion.
Great. So I'm sure people are excited to have some questions, so I'll be open to yes. Pat.
No, well, there were many cases in the Israeli courts about the issue of the sperm of deceased people. Some of these decisions led to the birth of children, and maybe you refer to some of these early cases. The last case that I discussed was the only one that made all the way to the Supreme Court. And in that Supreme Court decision, the precedent was made, and in that particular case, there was no wish of the deceased. Well, he did not leave the sperm. The sperm was taken from his dead body, and then a decision had to be made about the future of it. So, so this was a very, I would say, extreme case of a sperm taken from a corpse, if you allow me, this was the fact, and then the question was what would be the future of that sperm. Well, there were many stories and cases of gay men who went through surrogacy process abroad. In general, it is possible to come back to in Israel and get registered, etc. And Shahar mentioned, so I'm not sure what was the particular case.
I will.
Okay, please.
Yes. So, first regarding your first question. So, until recently, the test of the court was if there is a written will of, so they just obey it. If there was not a will, so the only question was what is the implied will of the deceased. Now, in almost all of these cases, the state object, and then the lower court slowly enable more and more alternative to do it. In one of them, it was even when the partner opposed, and there is currently another very interesting case in which there is no partners, and the grandfather and the grandmother want to take care for him by themselves. In other cases, they want that there will be a mother and there will be some relationship with the children. In this case, they want to grow up the children without father and mother. The family court enabled it, and the appeal court now reversed it, and this will come to you.
So let's not discuss it.
So you will not discuss it. To your second question, what happened in this Indian case was like this. We have a biological father, and we want to enter his children to Israel. But our Israeli law knows that the children is his children. So there is a procedure that he make DNA test in India or in other countries, in the consulia. Then when the test is done, then he is allowed to bring the children to Israel. In the case that you mentioned, there was a disaster in India, and they want to do it quickly. And then there was technical problem because until the test was done, there is no official way to enable the children to get in.
By the way, there may be another complexity in some cases where the two gay men involved don't really want to know who is the father.
Yes.
So because they want to raise the child as the
There is a
their
Supreme
son.
Court case about it, Mehmet.
No, so we could get into all the options, but this is another matter. Yes.
Yes.
This is more procedural or general question. In the U.S. or even Jewish law, when considering a case, you're referring back to some constitutional law as your source of reference of whether the law is consistent with it or contravenes it. How are cases? How does the Supreme Court? What is the reference when you say that in any of these cases when you're deciding that this is a better option than that, or this option? Is this just because you think it's a better option?
Oh,
you think good
not
argument,
at all.
Or is there something that you refer back to as whether it's consistent with that sort of outcome?
Okay. Your question is really connected, I would say, to the basic features of Israeli law. What kind of law do we have? I mean, is it a statutory law? Do we follow precedents? What are the guiding principles of the system? So very briefly, I'll say that, as we say in multiple choice questions, all the above. So I mean, basically our first reference is the law. In some cases, there are statutory provisions that may be relevant. In general, we have a system that is very much based on precedents. This is something that we inherited from the time of the British Mandate. So although we are not formally a common law system, we have many of the features of the common law systems in the sense that precedents are very important to the growth and development of the law. Just because of the limitations on the length of the presentation, I couldn't get into all, I would say, the details of the reasoning, because I just wanted to map the questions. But obviously, in each of these questions, I mean, statutory law was relevant, precedents were relevant, and also, referring to your question, constitutional principles. For example, the right to be a parent is considered some kind of a basic right in Israeli law. Well, this is yet another presentation, but so in a nutshell, I will say, yes, that we don't have a full formal constitution U.S. style. That is one document that is the, I would say, source of constitutional law. Having said that, it doesn't mean that we don't have constitutional law or that we don't have a constitution, because there are other models of constitutions in the world. More specifically, Israel has a series of so-called basic laws. That is super laws that are not ordinary laws, and they are supposed to become chapters in Israel's future constitution. And until we finalize that constitutional project, there are many historic reasons for that I cannot get into, but from a functional perspective, the view of the Supreme Court is that these basic laws are considered to have a constitutional status. They are the basis for judicial review of ordinary legislation based on what's written there. It's still not a complete constitutional project, so there are some holes that have to be completed, but in terms of from the institutional perspective, they function as a constitution, and therefore their provisions are also relevant to making decisions, especially in hard cases of this sort.
I would like to add something about, because I agree with Judge Baraker that in a lot of these cases there are precedent and there are legislation sources. However, I think that you're right in your intuition that there is a very interesting process of what happened here. What happened here, and it is very similar to what happened in Israel in marriage law. that officially there is law, which is religious law. A lot of people are not happy with the religious law for very variety of justified reason. And then the court develop alternative, for example, cohabitation. And because it become not without systematic way, sometimes it become without limited. For example, in Israel, to be cohabitant even after 3 months or something like this. How it connected to our question? Think of the issue of the surrogacy agreement law. So the reason that in Israel we are not allowing the law to signal and to same-sex couple to do it is not because the nature declared it. It's because religious parties oppose any change to this law. We have to put it on the table. Now, what happened is that because the religious parties are not ready to any change, then the system shut its eyes to the fact that it happened, but it happened not in Israel, but overseas. And then when it happened overseas, we lose all the benefit of regulation. Because if you look on the surrogacy agreement law in Israel, yes, some balances, which kind of parent can do it, what should be the relationship. All of these issues are lost overseas. A lot of these surrogate women are poor women which are being humiliated, and no one supervised about it. See, if the Mor Yosef cases was not this disabled person, but she could go aboard, then again she could do the same thing. So because Israeli law, Israeli society is not able to take responsibility of itself, then there is like kind of vacuum in which court try to work, but court fail to do it in a systematic way.
May I say that I agree and disagree with Shachar at the same time? Because, I mean, I agree to the description of the dynamic, but I think that at least partially, this is not, it does not come to the members of the legal community as a surprise. I think that the price that it is done elsewhere is known, and sometimes those who make the decisions are even interested in that.
Yes.
It's not, I would say, an unintended consequence.
No, it is
It
just...
is an intended consequence, because sometimes in politics or in law, symbols are considered more important than
But-
the functional aspect.
But then we have to...
Others just think it's an intentional application of responsibility.
Yes.
Okay.
But you agree with me that there are some balance that we would do, and we lose it when we are doing it abroad without almost any supervision.
I wanted to say that sometimes it is intended and sometimes it's unintended.
Okay, okay. It's fair enough.
Yes.
Pleasure to have you, and Nana, and very interesting listening to you. It's very interesting listening to Esther, just constitutional law actually say that. And that's actually the second thing family law is that constitutional law keeps strengthening many of the statutes were enacted before 1992, and thus they enjoy protection against not be actually violated by the court, enjoy protection against tradition. Now, a few years ago I participated in a conference which actually discussed adoption and cases of coerced adoption, where you actually experience not going to give away the child, but the state takes away the child from the family. And those are the worst cases, the harshest cases, and harsh. And as you read the cases, you see that there's no mentioning of constitutional rights of the parents. But you take away the child and, okay, maybe this is the right decision, but don't the parents have constitutional rights? No mentioning the constitutional rights of the baby. Now, the parents change because I had in family
It's changed.
family
Yes.
law and constitutional law. But that brings me actually to the question, and that is, if that
Okay, maybe I'll just clarify the question with a sentence or two, maybe to some of our participants, and this will help me complete my question, my answer before about the role of the Constitution, and then I'll get back to your question. Because what Professor Weil just mentioned or reminded us is that although the basic laws function as a constitution, there are some, I would say, limitations on that description. And one limitation is that as a matter of political compromise, regarding the basic laws on human rights that were enacted in 1992, the political compromise of the time was that the new constitutional regime will apply to later legislation, to legislation that will be passed after 1992, whereas former legislation will be immune from judicial review based on the standards that were only passed in 1992. So this is kind of a political compromise that is in place for the time being. By the way, the Supreme Court has stated at a relatively early stage that although prior legislation is immune from judicial review, it should be interpreted as much as possible according to the standards of the new basic laws in order to make the clash less extreme. So in this context, the question was, what is the role of constitutional law in the context of family law, remembering that many of the basic features of family law in Israel were passed prior to 1992 and therefore are immune from judicial review. But I have to be very careful in what I answer because these are probably the new questions that will come to the court, and I would not like to give a pre-ruling on things that may come to the court. So I have to be very careful about what I say. But I think that part of the answer was offered in what I've said so far, in the sense that there is no question that even with regard to prior legislation, even the most conservative on this issue would agree that there needs to that we really need here very strong interpretive effort to be made and invested to make sure that we live as much as possible to the constitutional standards. As much as possible is as much as possible. Not always it is possible, but we should make the effort. But I want us to bear in mind a few other facts. Second, we should remember that although a large component of family law legislation is the, a large component is the prior legislation, we don't, law does not stop. And we have new amendments and new laws. Just for us to remember that the surrogacy law that I mentioned is from 1996, and this is a modern law. And this is, and at least formally speaking, no question that it is subject to judicial review with all the post-1992 standards. So not everything is immune from judicial review. Again, I'm saying it in a mere descriptive mode. But on the top of all this, I want to say another thing, and that is, even if constitutional law applies, does this really mean that constitutional law as such really offers clear answers? Think about American law. How many years American law needed in order, for example, to recognize the concept of same-sex marriage? And still, there is an there are ongoing controversies. So even if we have a constitution, even if other countries have constitution, these are the type of questions that not necessarily constitutional law itself may give us very clear answers. Constitutional law is just like a starting point, but not necessarily an end point. So I think this is the reason why I didn't start with constitutional law. Because I believe that even if we have tomorrow a full formal constitution, does this really mean that the abstract provisions of the constitution will give us very concrete questions to new situations? Not at all. This does not say that constitutional law is not important. It is highly important. But let's not be naive, and I'm sure that you're also not naive about it, that the Constitution as such will tell us what is the right solution to a specific new scenario. Even with the Constitution, we will have to still think about it using theoretical concepts of justice, to think about precedents, to think about analogies, also to understand what the Constitution dictates to us.
So I think probably, I'm sure there are lots of other questions, but I think we should maybe thank our panelists and give you the opportunity to ask them.
Sorry. So two very quick things. One, those of you who have CLE, C.R.E. Mermelstein, okay, right here. And two, many of the decisions that have been described tonight are on our website, including both Nachmani decisions and the Jane Doe decision. Not the harvesting sperm or making a baby decision yet because they're too new, but they will be eventually. So that's Versa, V-E-R-S-A, versa.cardozo.yu.edu, Versa. And so I hope you'll go on and find it. That's all. Now we can thank our guests.